Those that are sought permission to remain seated, you should remain seated. On grounds of not feeling well, the same permission still subsists.
Prosecution, Sharon Nambuya, Sarah, resident Chieftain and Kawempe, representing the state, together with Mr. Tanjira Bruce, who represent the state.
Thanks.
Your Honor, we reiterate an humble prayer.
Compositions are still introduced. Before we proceed, Mr. Jackson, it will be Eddy. Alias Eddy Mutwe.
Giant niteyongera bulungi.
I have been for the defense. I have been joined by Counsel Samuel Frank.
When court responds, it's the prosecution that's not goes to court. We pray that will be given that time, but goes to court.
I'm going to just break what were you saying before?
Yeah. When we broke off, the defense was already withdrawn. And the defense had intimated this honorable court that we were ready to proceed with the purity. We had intimated to present two sureties for A1 and A2. The same had been uploaded on Equities, but we seek guidance. The same were also uploaded. The sureties were uploaded on Equities, and we seek the guidance of this new court on how to proceed.
Worship God, we seek God's indulgence. And guidance may be the word.
Yes, I think you stopped at that.
Yes,
Worship, there is an application for bail by God that correct. My learned colleague has just told the court that they have uploaded documents and introduced two sureties. Certainly that is a bail application. I pray that the court is pleased to expand that from the record. The application itself, for the reasons that
Yeah, we still have that flow.
It's an objection. For the record of worship, and for purposes of having a clear record, state loose during that state after almost the first half of the proceeding has been conducted. It's just jumping on a conclusion. Yes, it's jumping on a conclusion on a matter you have
It's not
started.
jumping.
Everything is
Here, let's respectfully hear from the objection, then you
It's jumping on a conclusion how the subject matter is not about to be expanded on record that he has no knowledge about. It is premature to pray that the record be expanded at this point. Have the record expanded.
But if that is the objection,
It's have the record expanded when we are seeking court's indulgence in order to finalize our
it's a matter of law or
just a minute. my guidance is as follows. Since he was actually making his response, let him make it. He has an opportunity to.
Most obliged, Your Worship. Most obliged. With respect to my learned brother,
Yes, then.
if I may digress a bit. I may not have been involved for the past few minutes, Your Honor, but I've had the benefit of looking at the record. So, Your Worship, I pray that
Maybe,
the record my learned sister.
maybe it's guide court, Your Worship, and guide the state. By the time we have done this matter, we are on the point
Your
where
Honor,
we
we
are
are
praying
subject, Your Honor.
Can I talk and
Say something, Your Honor.
Excuse
Let
me.
me,
Just excuse me. You see, in the first instance, we need to have order in front and respect each other when speaking. So what I want to guide on is, I'm going to give you an opportunity to speak and raise. By the way, another files waiting. And just for the last 1.5 hours, I'm just handling this one file.
yeah, right.
Yes, so let's listen to each other. I'm going to let you speak, but speak with respect to each other. Please keep and maintain the decorum. Okay.
Right, Your Worship.
Your Worship, my learned brother interrupted before I could give my reasons for my prayer. Your Worship, my prayer is that the record so far this morning is cleared of what has been submitted. Your Worship, firstly because, especially Your Honor, in regards to the bail application that my learned brother is trying to make, that he has made already, that's what he has told me. Your Worship, my reasons are as follows. Your Worship, when this court broke off on the 3rd of October, rather condemned. Your Honor, they say the trial magistrate, having made a ruling on the applicant on the 3rd of October, the trial magistrate made a ruling on the bail applications of all the applicants in court. Your Worship, the trial magistrate, Worship, I understand is away for officially. Your Honor, when she adjourned this case to today, Your Honor, two things were anticipated. Your Honor, that in her absence, the case is mentioned. And in the alternative, Your Honor, the ruling is by the accused's application. Be for review and not an application before Your Worship. Your Worship, the law is very clear. Your Worship, this court this court, Your Honor, has no jurisdiction to entertain this case. Your Worship, for the obvious reasons that this offence attracts a maximum of 7 years should they be convicted. Your Honor, therefore, the court cannot be seen to entertain an application of this nature or any, because should they be sentenced or rather convicted, the sentence is way above the jurisdiction of your court, Your Honor. And therefore that affects all other applications, including the application for bail that has been made before Your Honor. Your Worship, in the case of I am happy to share a copy of the same with my learned brother's counsel for the defense, or rather the counsel for the applicant. Your Honor, in the case of Uganda versus Katanga Mori and 4 others, made this position very clear, Your Honor. This is beg your pardon, criminal revision case number 1 of 2024, arising from criminal revision case number 1 of 2024, arising from Nakawa criminal case number 43 of 2023. Your Worship, this is a High Court decision. The application was in fact made by the Office of the Director of Public Prosecution. Your Worship, the court had this to say. This is a ruling before Justice Isaac Mutwe. Your Honor, this is what the court had to say. Briefly, the facts of that case were Magistrates Court in Nakawa had proceeded and entertained a bail application in a case which had a murder charge. Your Honor, the case I've just cited, Your Honor, the court had this to say. The gravest offense, Your Worship, I am paraphrasing some of these, but I will quote verbatim where necessary. The greatest offense on a charge sheet determines the jurisdiction of which court to be handled. Rather, the greatest offense determines the jurisdiction of the court. It is therefore founded and offends the law. I beg your pardon. This is, I will quote now verbatim, Your Honor. Beg your pardon. The magistrate, the judge had this to say. The magistrate was therefore only required to advise the respondents who now are the applicants, Your Honor, that he did not have jurisdiction to hear the case and that they would only take plea and apply for bail in a court with jurisdiction. And the court therefore remanded the accused that did not have jurisdiction to hear the case and that they would only take plea and apply for bail in a court with jurisdiction. And the court in fact cancelled the bail of the other accused that had been admitted to bail, who had other offences other than the gravest of that was on the charge sheet, which was murder. Your Honor, what am I saying? The question of jurisdiction is a matter of law. This is my it's a matter of law. Whether applications arising therefore it is only a court with jurisdiction to entertain the same. Your Worship, I will go back to the ruling. It is only the court with jurisdiction over all the counts in the charge sheet that has power to take plea, hear, and determine the case or grant bail. Your Worship, this is the crux of this ruling. It is only a court, Your Worship, and quoting verbatim, it is only a court with jurisdiction over all the counts in a charge sheet that has the power to take plea, hear and determine the case, or grant bail. Most of that. Your Worship, this is at page 3. It is only a court with jurisdiction over all the counts in a charge sheet that has the power to take plea, hear and determine the case or grant bail. Your Worship, we invite the court. It cannot therefore purport to hear an application that is not rightly before it for want of jurisdiction. With those reasons, I pray that the court is pleased to expunge all that has been said, or rather submitted upon by my learned brothers, counsel for the applicants, in the guise of a bail application, and yet the court has no jurisdiction. We pray that the court is pleased to in fact expand the same. It's over.
I associate myself with and very intelligent submission of my land colleague, Bruce Wanjiru. This court has no jurisdiction to entertain whatever the defense was calling a bail application. Your Honor, we said in our opening statements, there was already a bail application where court ruled that the sureties were lacking. Section 76 that the defense quoted of the Magistrates Courts Act only applies where human rights have been abused and the suspects have never appeared before court. Yes, I'll read the law to apply for bail of the NCA, Your Honor. Where the state is incarcerating accused persons without giving them a right to apply for bail within the context of Section 28 and Article 28 and Article 23 of the Constitution. Your Honor, this is
So you're saying, I'm here to appreciate your argument for submission. Section 76 of the NCA.
I'm saying this question, Your Honor, is different because
The argument was that Section 76 what they do or not do.
the mandatory bail that the defense was talking about. Your Honor, we shall provide this case law, which shows that where the accused persons are detained and they've never been given a chance to appear before the court, they may benefit from mandatory bail. But in this case, Your Honor, there was an application. A prosecution ensured that the due process, the accused were presented, Your Honor. And they applied for bail. And then the prosecution shall respond to those fresh bail applications. Your Honor, Section 76 literally says, restriction on a period of trial remand. Section 76 of the Magistrates Court Act. If an accused person has been remanded if an accused person, Your Honor, has been remanded in custody before his or her trial commences, A, in respect of any offense punishable by death, for a continuous period exceeding 180 days, B, in respect of any other offense, for a continuous period exceeding 7 days. This is the gist now. The magistrate, before whom the accused person first appears after the expiration of the relevant period, shall release him on bail or on his or her own recognition. Notwithstanding that he or she is accused of an offense referred to in Section 75. Your Honor, this section can be interpreted to the party, can best be interpreted by a party that seeks to benefit from it. So the difference is doing. Your Honor, L1 has been on remand for 17 days only. Yes, L1 has been on remand for 17 days. We can authoritatively show that. And Your Honor, within the context of Article 23 and 28 of the Constitution, it's accused right to apply for bail, but this bail is not like it's an absolute right. The right to apply for bail in Uganda is that anyone can apply for bail. But it's not that it's a right that to be given. It's within the discretion of the court. Your Honor, allow me to read Rule 3 of the Constitutional Bail Guidelines. It says, summarily, that in determining bail, the court should promote the balancing of rights of accused and those the accused persons with public interest. You know, there were affidavits on the court record which we presented before this court, and we vehemently pointed out that this case pertains on public interest. That it would be undesirous for the court to grant an accused person's bail because it would be contrary to public interest.
That is already on record, isn't it?
And in denying the accused person's bail, that ground was clearly stated by the trial court that it would be against public interest to grant the accused person's bail. Your Honor, like my land friend, Bruce Nigeria has clearly stated that this court lacks any application by the accused persons. We pray for an adjournment so that the defense lawyers can apply for bail before a court that has a right jurisdiction to entertain this case. It's so pray.
just to supplement, the court with jurisdiction has the discretion to grant or not. When that has been settled, the judicial officer, the trial magistrate, makes her ruling in regards to all the applications made by the applicants before him. You know the question of mandatory bail that my learned, the applicants making before this honorable court. This question is a matter of law. Rather, this jurisdiction is a matter of law. And it cannot have been intended, Your Worship, that it is any judicial officer, including an officer by 76. It certainly would not have been the intention of the framers of the law.
My Lord says section 76 of what?
Of the EMCA. It certainly cannot be the intention of the makers of the law that the first judicial officer, before whom the applicants appear after the expiration of the mandatory period, that they can entertain and grant. Certainly not. Your Worship, this can be a matter of constitutional reference. Your Honor, we insist this court has no jurisdiction to entertain the application. Therefore, the same ought to be expanded because the law is very clear. If you have no jurisdiction, you cannot entertain, not even the plea. All applications arising therefrom, including bails, that my learned colleagues, counsel for the defense or applicants, are trying to smuggle and mislead the court. Your Worship, we respectfully insist this court has no jurisdiction, and we pray that the record is made straight. And if the applicants insist on the release on bail, the options are only application for review before the chief magistrate. In the alternative, an application before the trial magistrate who has the jurisdiction, rather jurisdiction, and not the court without jurisdiction. We so pray.
Most obliged, Your Honor. The fact when a matter of law is raised, the court before which such matter is has to hear it. It is a matter of law. The court. So, having raised an issue of jurisdiction, it only pertains at a decision on whether this honorable court is clothed in the jurisdiction to hear us is concerned, it has to be there. Again,
Most obliged. That is
Again.
fair for you.
again, it pertains, Your Honor, that the basis of such an application, out of which a decision is to be made on a point of law, cannot be expanded, because it's the raw material. It's the basis. You may not, on one hand, say on the basis of the application that was made, you do not have jurisdiction, and you want the basis to be expanded. That's ridiculous. So the first being the application for expunging would be incompetent, unreasonable, wayward, and a breach of the principle of a hearing. Of a fair hearing. Your Honor, the benchmark of their submission is premised on section 76 of the MCA. Which my colleague will. It is premised on section 76, which is clear and unambiguous. But their argument, my colleague, is that you can only hear us when it is a matter of rights being abused. That is proper. But you can only hear us prior to trial if there is a right that has been abused. Yes. And I agree that it is circumstances like this one where the right to liberty is being curtailed unconstitutionally that we may be heard. To take you back to the record. Take you back to the record.
Your Worship, my learned brother cannot refer to this trial as unconstitutional when the charges are properly before the court. That cannot, Your Honor, certainly be left on the record.
I thought
He cannot proceed.
Let's hear. First you hear, you internalize,
You say the trial.
and contextualize.
The charges. Your Worship, say the charges.
You have not contextualized. It is unconstitutional.
Bagenda kwekuba.
Certainly can't be on record that they are unconstitutional.
The report.
That's not what I'm writing here, but
It is unconstitutional to curtail the liberty.
The trial.
Liberty.
it's talking about liberty. Let me
Okay. I'll take you to liberties now. Probably that's where we need. Your Honor, first I'll take you back on the record. Our learned colleague on opening, in her opening submission this morning, Your Honor, it is on record that my learned sister submitted that this matter came up for ruling before this honorable court. On record. And that would only have a right to a fresh bail application. That is on your record. Now the same state has come back to state that the bail ruling may only be subject to review and not a fresh application. These are two positions from the same.
Can we
side.
Your Worship, my learned, he's leading the court, Your Honor. I gave two options: review before the CM and a fresh application before the trial magistrate who has jurisdiction. He's selectively putting to mislead the
that's
court.
what the last state happened.
He is misleading the court.
Yes, I guided on that.
Most obliged, Your
We
Worship.
are
Most
right.
obliged, Your Honor.
Your Honor, my argument stems from the fact that actually this is a right. It's a human rights matter being abused. Your Honor, we have a case which has summarized this. I invite this honorable court to look at Kizabesi versus Uganda. This was application number 228. This was application number 228. 2005 and 229. It was bail application 228, 2005. Bail application, sorry. 228, 2005, and 229 were consolidated. 2005 and 229. And you'll find at page 2005. At page 6 of that ruling, you'll find Ogora PJ, as he then was, emphasized the role of court, for emphasis court, in protecting the right to liberty. This is a matter of human rights. Protecting the right to liberty. And verbatim, he asserted the right to liberty in the following terms. In bail terms, Your Honor, that I have taken into consideration. This is verbatim. I've taken into consideration the fundamental importance of bail as a protection of the right to liberty. Fundamental importance of bail as a protection of the right to liberty of an individual. The said liberty, in his words, is next only, it is next only to the individual's right to life itself. Our emphasis is on this as a right, human right. We are certain.
Are you still counsel responding to the
Yes,
point
right.
of law?
Point of law, it is a point of law. The argument is you can only entertain us if a human right is being abused. Now, Ogola PJ put it clear.
Even when there is contention from the other side that the court that has.
That is the argument. That is the argument that any court emphasize, we say the court, emphasize the role of the court. Irrespective. Yes, I'm going to supply.
Please, I want to reiterate this. Let's listen. That's the reason we've dedicated time to this interview.
I'm off record.
Please,
I want the state, off record. I want the state to look at these people. We're talking about rights. I don't think it's only us, but also a duty bound. If we are speaking about rights, that's why we are emphasizing, Your Honor. The state should not look them as adversaries.
Your worship, off record also.
Yes.
What my learned brother is forgetting, that the court with jurisdiction has the discretion to grant or not. Yes, that is what my brother is forgetting. A court with jurisdiction.
Well, maybe it doesn't work here. May we just be verbatim, then my colleague will take up. Let me be verbatim, then court will decide. These are the words of the
I
law.
think that is what we should settle for.
Yes.
Okay? Let me hear your arguments, your submissions, then we'll do the voting.
I'm obliged. I'm obliged. Ogola just stated that the right to liberty is next to the individual's right to life itself. And that liberty is so crucial in a free and democratic society. Liberty is so crucial in a free and democratic society as breath is to life. Is summarized as I conclude the last that give me give me liberty. We intend to make a prayer for our colleagues when
Let me let me listen to the vote. What is that? What is that?
There are some classifications which are blocked. Mr. Watson.
We will get to that. And this is the councils, those cards are blocked, the police card. And that one you can do quietly by whispering. But what if it's the one submitting? Is there now going to stop there and then go to remove the card? Let them just be a little patient, okay? And talk to them quietly.
we can summarize. We appreciate.
Just quickly mention those numbers, they will get to know. Since we meet up with them.
CPA 852M UAX 926. Yes.
Well, to summarize, the brief in this statement was give me liberty or give me death. This is how it went. He stated, give me liberty or give me death. In summary, that is what Learned Ogola stated. So, an issue of life and death qualifies life and death qualifies as a human rights issue. That may be entertained by a court. Pre-trial. By a court pre-trial. Before a trial. Even at a stage of pre-taking, when a magistrate may attain to pre-taking or at any stage. And I conclude by saying